Welcome to our third video in our series on reviewing the text of the FDCPA. My name is John Watts. I'm a consumer protection lawyer in Alabama, and I appreciate you watching this video. If you missed the first two, you might want to pick those up, and you can find those on our channel. So in this particular video, we're going to be covering Section 1692B, which is acquisition of location information. Just as a review, 1692 was simply what did Congress find and what's their reason for passing the law. 1692A is a list of definitions, so we can figure out, is this a consumer? Is this a debt that's covered? Is this a debt collector? And now we get to this, which can seem kind of odd. Why have acquisition of location information? We already saw in the definition, location information is where you live, your home phone, and where you work. Well, the reason is in the next section, 1692C, we'll find out that we're not supposed to, as a debt collector, talk to third parties. And the exception is what we're looking at right now, 1692B. So a debt collector is allowed to talk to a third party to get location information. So let's see what that means. So it says any debt collector, and that's important because sometimes we have debt collectors that we sue, and they'll say, well, this was medical debt, so that's different. Or this was credit card debt, or this was a deficiency after it doesn't matter. Any debt collector communicating with any person other than the consumer, remember the consumer is defined as the person that owes the debt or allegedly owes the debt. So communicating with any person other than the consumer for the purpose of acquiring location information about the consumer shall. So this tells us you only get the protection as a debt collector. You only get the protection of the 1692B if the purpose of your phone call is acquiring location information. Sometimes debt collectors, this is sort of a classic dirty trick that they do, and it kind of comes in and out of style for them, but they'll call your neighbor and say, hey, I was trying to reach Bob. And say, well, this is Jack, his neighbor. Say, oh, well, have you seen Bob lately? I think Bob, he was really sick or something. I've been trying to reach him and haven't been able to reach him. I'm really worried about him. Could you go knock on his door and maybe get him to call me? Well, see, that's not for the purpose of acquiring location information. So location information, home address, home phone, where you work. So it says, number one, you have to identify yourself and say, hey, I'm confirming or correcting location information about the consumer. And you cannot state as a debt collector the consumer owes a debt. And you can't communicate with that third party more than once unless you think that the information you received from them was inaccurate. And now they have the correct information. So again, this is something we probably filed this lawsuit 15 years ago. And it was something like this. A debt collector calls a neighbor and says, I need to speak with Bob Smith. Neighbor says, I'm not Bob Smith. Well, give me Bob Smith's phone number. I don't know Bob Smith. I just moved here 6 months ago. Debt collector says, yes, you do. You know who Bob Smith is. You tell me his phone number. I don't know his phone number. Debt collector says, well, I'll be calling back. And true to their word, they call back over and over and over. See, that's not right. Now, they would say, well, we thought that the person, the third party we contacted was lying. We better be right about that. Better make sure that they're lying and that now they have the correct information. So this is something that we sue a lot of debt collectors over. So it's very important that this is in here. And then the rest of this section is number 4, don't communicate by postcard. Okay, because there's no privacy with that. I mean, the mailman looking at the postcard could see, oh, this is about a debt collector. And then number 5 is don't do anything in the envelope or any communication that indicates that you're in the debt collection business. So if the name of your company is, We Collect Debts LLC, well, then you can't be sending a letter because that kind of gives it away. Or if you put on there seeking location information for debt collection purposes, that would be wrong. And I'll say this, I'm not sure I've ever sued a debt collector over trying to get location information in any way other than phone calls. Maybe this used to be, but I haven't seen it in many, many years. So, and then number 6 is if the debt collector knows the consumer is represented by an attorney on this particular debt and they can find that attorney's name and address, then they can't communicate with anybody other than the attorney unless the attorney fails to respond within a reasonable period of time to communication from the debt collector. So that's the idea here, is that if you, as a debt collector, know that the consumer is represented by a lawyer, you got to talk to the lawyer. Now, if you can't reach the lawyer, or the lawyer won't call you back after a reasonable period of time, then you can choose to talk to the consumer. It's pretty dangerous. We'll get collectors that say, I've called you half a dozen times, you didn't call me back. And every call that comes into our firm is logged in, and of course they've never made the phone call. And we kind of avoid this issue because I don't ever deal with debt collectors until after I sue them. And once we sue them, obviously they know that we represent the consumer because our information is on the court file. So they have no business contacting the consumer, even though they do, and which is terrible and great. It's terrible because they're completely violating law. It's great because now we have another lawsuit against them, and they really have no defense to it. We sued them, we served them, we're in the middle of taking their deposition and other stuff, and they're sending letters to our clients. It's just outrageous. So, and it costs them a lot of money. So that is this little section 1692B. Again, it's kind of an odd section in there, but it's important because the next section we look at, subsection C, is going to be about talking to third parties. And so you'll see this section is referenced in the next one. So I hope that this is helpful to you, and thanks for watching this series. And feel free to like the video or subscribe to it, and that way you'll get notified when we have other videos in the series. And we'll just keep marching through these subsections. A couple of these will be pretty long, and so I'll probably break them into 2 or 3 videos. I'll just see how it kind of looks and try to keep these from being too long. So thanks again, guys, for watching this, and I will talk to you in the next one. Thanks. Bye-bye.